Hello, hello, hello. It's Tuesday. You ready to talk some crime? Yeah, I got some legal cases that had some very interesting twists recently. Hearings and filings and, well, letters. Hey, look at the trees. Hmm. Craven and Turtle and Purple and Gin. Yeah, good to see you. It is going to be three different cases tonight, and well, I could give you your choice, but I think I'm just going to go in order on how we have things situated here. The first one is one we haven't talked about in a while, and that would be in the murder of Obsami, both Christian Abonsali, and that would be the OnlyFans model, Courtney Taylor, aka Courtney Clenney, who has been charged with his murder out of Miami-Dade County in Florida. And, well, last time we spoke, let me bring it up first. These are the three we'll be talking about tonight: Karen Reed, Courtney Clenney, and, oh, there she is, Sarah Boone. Yeah, we're going to talk about Sarah Boone too. And for that one, you're going to need to buckle up. Definitely. Okay. So, right now, let's go into Courtney Clenney. Still facing homicide charges in Miami-Dade County. However, there's been a ruling in regards to the Miami-Dade County prosecutors. And, well, what we talked about last time we talked about Courtney Clenney was that the prosecutors had filed charges on her and her parents, Kim and Deborah Clenney, for illegal attempting to access a laptop that was found at the apartment, and they accused him of hacking and not turning over the evidence or whatever. Just kind of shady. But what actually happened is that after the search of the apartments, and when the prosecutors or the state had actually turned the apartment back over to Courtney Clenney, the laptop was found. And, there was discussion about checking it. But this laptop did not just belong to Christian Obsun Saleh, as was proven by Courtney Clenney having things on that laptop that were hers. It was shared, and she had all the passwords, which she wouldn't if they didn't share it or they didn't confide with each other. And it was left in the apartment. Now they did approach the attorneys with it, and here's where the problem starts. There were conversations between Courtney, her parents, and her attorneys, Sabrina Puglisi and Frank Pireto. These were email exchanges and text message exchanges in regards to what to do about this. So they decided to give it to an investigator to have it looked out. But what happened was the prosecutors got a hold of those emails. And that's why they did the charges, because they were assuming that nothing was going to come to them. It eventually all got turned over to them anyway. But they charged them with illegal hacking of the laptop. Now, there was a hearing just recently, Thursday, as a matter of fact. And, well, it didn't really go the way the prosecution would have hoped. Oh. From the start, Courtney Clenney got a separate attorney. There's attorney Fabamoto, who actually represented the parents and Courtney. And they went before the same judge, Judge Laura Cruz. Okay. This is from the trial date. Remember, Courtney Clenney had petitioned the jail to offer better makeup and hair services to those that had to go to court for hearings and trials. And it's been doing her well. She's been looking a lot better. She's been looking really good, actually, for someone that just can't get out of jail based on these trials, the bail hearing and whatnot. She was denied. She was denied bail based on her statements. Her ability to make money from anywhere was the chief thing, because even though her OnlyFans account was canceled, because of the amount of people she had and the notoriety of her name under Courtney Taylor, it was a risk. They said she could make those millions, as she was making millions, from anywhere, and just start another account. So she was a flight risk. Her father testified at the court. about transferring money, that she didn't have a lot of money. They bought a house, they paid lawyers' bills, etc. If they proved that she didn't have a lot of money to leave, but her ability to make money. And it was also the very damning statement by the coroner, who believed that her defense statement of throwing the knife in self-defense at Christian Obasali was a probability that couldn't possibly occur based on the wound that killed him and how deep that penetration was, and that she'd have to be an expert knife thrower to be able to accomplish that. That was more likely that it was caused by a thrust of the knife a little closer up. Courtney has said in her statements to the police and in her affidavit that she was at least 10 feet away in the interview that she gave when it happened. And unfortunately, the coroner is disagreeing with that, and that went against her also in the bail hearing. That's why she's still there. But back to this other case that we just had the hearing on. Now, the result of the case, after hearing testimony from her attorney, Frank Prieto, actually took the stand to testify about what happened, how they found the laptop and everything. They gave evidence to Judge Laura Cruz. In August 27th, a while ago, she actually ruled that the prosecutor's office was in violation of attorney-client privilege when when the investigators confiscated text messages and emails between the Clenneys, her parents, and her attorneys, because Sabrina Puglisi and Frank Prieto, because they also, after they were pressed charges, because they were cooperating and turning everything over. When the charges came through, they actually produced, you know, a a letter of hire with the attorneys between the parents. And so basically, they actually had confidential information on there. And it was more than just talking about the laptop. They talked about their defense and what they were going to do. There were strategy conversations on there. They received everything. And that is where the problem lies. So the court ruled that there was definitely no way to go forward and that none of these correspondence could be used in the case. And without all this correspondence, the hacking laptop case just kind of fell apart. And so the prosecutors voluntarily withdrew the charges. They call it something pretty fancy, like nolle prosse or something like that, which means, they're volunteering to remove the charges and to drop them. Basically, I don't think they really had any choice if they don't have any of the collaborating evidence that proves that they were, talking amongst each other about this laptop and what to do. They could use none of the evidence that they acquired that way, none of the communications between the parties that they're charging. Now, this doesn't affect the homicide case as far as the emails being removed, because none of that was evidence that was going to be put forward by the defense or the state in that case that we're aware of. But so these charges are just dropped. Okay. But it does present another problem, because both Frank Prieto and the judge, this is her parents, by the way, that's Kim and Deborah Clenney. And they got to see their daughter in court. Not a pleasant way to see your daughter, but yeah, facing the same charges. They actually found it, like, there was a lot of uproar when the charges were actually made. If you'll recall, they actually arrested them in Texas and jailed them and extradited them to Miami-Dade for the hearing. Okay, instead of just serving them to show up, which they would have. They didn't even give them the opportunity to do that. They actually really embarrassed them. And actually, it is the Clenneys defense attorney's position that it was done on purpose to take credibility away from anything that they would do as far as testimony in regards to supporting Courtney in the fact that Christian Ophthalmic contributed to some of the abuse in this relationship. It was obviously a very volatile relationship. There's plenty of video evidence we have seen to both ends, to where she is overly excited and saying she's being threatened, to where she's also pushing back and kidding and fighting, and there's a lot of it. There's a lot back and forth about this. Several videos back and forth that have been entered into evidence. Some of them released from Miami-Dade. The most damning ones against Courtney have actually been released by the state prosecutor's office, which, well, that just speaks for itself right there. Um, as to wanting to get information out to tamper the jury pool and public opinion, so to speak. Um, Credibility issues. I got my thoughts about that. But anyway, Attorney Frank Prado, who is the co-counsel of Courtney's homicide case, which Sabrina Puglisi, you've seen her on Court TV and Law Network. They said Thursday that the prosecutors were tainted, okay, from having seen privileged, confidential conversations about the homicide case among Courtney and her defense team, including investigators and legal staff. Prado said he's prepared to file a motion to recuse Miami-Dade prosecutors if they don't, and I quote, ethically do the right thing. Now, for me, I think once a judge has said that you violated attorney-client privilege and that you have read things that you shouldn't have been privy to, how do you unread them? I mean, really, seriously, how are they going to say that they would never use any of it? Like they know now, okay? And there should be different prosecutors on the state. I don't think it's enough to dismiss, of course. I mean, obviously, mistakes happen, errors happen, and they've been called out. But I think they need new prosecutors on the case. They need to remove all of that from the files and bring some fresh prosecutors in. That's not to say the prosecutors won't talk about themselves, but it would at least be a gesture in doing the right thing, okay, ethically. Because I don't know if you guys have read a lot in the news, but there is a lot going on with Miami-Dade County in the prosecutor's office. The DA's office is getting complaints everywhere about the prosecutors in several cases. Going outside the bounds of their responsibility, just doing things a bit shady. Not turning over evidence, doing, something like this. It's going to make the news cycle, and it does not make them look good. Okay. Now, Judge Fasadomo, he's from the computer case. He was the attorney for all three, and they were charged all together. He also is calling for the prosecution to step aside, and he said, and I quote, "This is really going to be an ethical litmus test for the state of Florida. We're at an inflection point. Judge Cruz found definitively that they invaded confidential communications, not just about the computer, but also about Miss Clenney's homicide case. There's simply no way the Miami-Dade State Attorney's Office can remain on that case." And I kind of agree. And we'll have to see what happens. Now, Courtney Clenney's homicide case has been delayed again and again. There's not a lot of movement. I don't even have a next hearing date. I assume once Prieto files a motion, if they do actually file a motion to have the prosecutors removed from the case based on this filing, which just happened, they have time. I hope to hear that filing has been made, and it would be to the same judge. Okay, Laura Cruz is the judge for the other case also. So, hopefully she already has in mind that she's hoping that they will do the same, that they will recruit themselves or bring other prosecutors forward. But we will see. We will see. There could also be, a special prosecutor could come in to prosecute, or they could just assign. The state could just decide to assign it to another office. Which would probably be the best and easiest thing to happen without a motion having to be filed and without the judge having to weigh in and demand that they be removed. We'll see. We shall see what happens on that. But we do not have a trial date yet for Courtney Clenney either. Okay. Okay. So next, Sarah Boone. Yes, Sarah Boone. In this one, well, I'm going to leave it up to you. Now, Sarah Boone wrote a letter July 8th to the judge again. And this letter is different than all the rest, like very much different. What you see there in the picture is actually what Sarah Boone has made an advertisement for an attorney, which I'm actually thinking I want to go over first before I read you the letter, because let's get the humor part out of the way first. Because, well, although I understand she's in quite a predicament, uh, I wouldn't want to be Sarah Boone finding out that I've got no choice but to, you know, just that I actually have to uh, defend myself, you know. Um, I would not want to find that out. You can imagine she was not thrilled. Who would be, you know? Um, but let me just pull up a bigger version of this. I have to bring one down and then the other, so that we can look at it in full. And then, if it's okay with you guys, I would like to read the letter if it's not going to annoy you too much. Uh, but yeah, let me bring up just the picture of the advertisement that she put out for a lawyer. And she's requesting that the judge put this in his chambers, by the way. She filed it and she wants to circulate around. Oh my. And it's handcrafted. She did this all herself, you know? I think Sarah Boone's missing. Like, I don't know why she's not working in, like, sign making and stuff. Like, she's got really nice handwriting and she uses big words, and she can make flyers and stuff. She could really, like, at least donate her services to other organizations. Wouldn't that be great? Yeah. Yeah. Client inclusion at all times. Yes. Did you read that? You're there. Okay. Inmate seeks attorney. Juju, I'm so glad you're here for this. Oh, do you? Okay, Mark, that's a very nice thing to say. Mark has struck the bear. Mark it off on your bingo card. He says me annoying him. He loves me annoying him in this. I hope a whole bunch of you feel the same way, because this letter is going to be annoying. But this is the funny part. Okay, listen. Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close up on national television? Are you zealous with a side of keen? That's one of my favorite lines. Are you zealous with a side of keen? Very cheeky, Sarah. Well done, well done. Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. Okay. Qualifications must include, and this is where it gets really lit, being trustworthy, honest, and passion driven, open minded, exceptional problem solving skills, client inclusion at all times, team oriented collaboration, extreme efficiency in listening, communicating, and understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining, and here we say with bold, faith in the client and the case, with the ability to think differently and overcome all circumstances. Let me just say, wow, right, Juju? Right? Like, oh my God. Yes. Client inclusion at all times. Her main complaint. They don't do what I want to do, and they don't take orders from me. Mm. They work with you. Yeah, you're not paying them, Sarah. Come on. Epic opportunity awaits. Sarah Boone and her prisoner number, Orange County Corrections Department. I love this hashtag. This is the hashtag. Invest in the oppressed. Believe. Just believe. Just believe, people. Yeah, just believe. It it's gonna be great. Okay. You know what? I just realized you didn't get to see that, so I'm gonna actually bring it back down to what I was just reading. But look at how she wrote this. Look at how she wrote this. It went up and it went right back down again. I do believe that StreamYards is sabotaging me tonight, but that's okay. I'm gonna muddle through. Do you believe Juju? I do. I don't think she's gonna like what either one of us believe, but I do believe that this is very well done. Look at how she scripted this out. You know, in all of this part here about the qualifications, like all like that. And I wasn't kidding. She put faith in big letters. Look at that. Look at that. Epic opportunity awaits. And here's the hashtag of the century: invest in the oppressed. We want to believe. We need to believe in Sarah, people. Yes. Sarah's on a mission. Sarah is on a mission. All right. While I get this set up. All right. Now I'm gonna have to read this snarky letter. Like, she's pissed. And she really is. Like, seriously pissed off. And I'm going to make it a little bit bigger so you can actually see it really well. Okay, because some of her writing, and if you guys actually think she said something in what I am actually going to say, please correct me, because her handwriting annoys me a little bit. It's very hard for me to actually understand exactly that's too big, every word that she says here. But actually, she just sent this to July 8th, and this time she put the honorable in quotes to Judge Michael Clenney, who's the judge on the case. Okay. Ari Sarah Boone, case number 1 on many websites. I, she only has. I searched her case site. She has only one case. Okay, this is it. She says one of many websites, and she puts the case number. She's being snarky from the get go. Judge Grading, where's my discovery? I am still waiting for you to provide me with the contents of what former attorney Cashman supplied to you in the court at the surprise status hearing held in secret on 6/28/24 at 1:30 p.m. I'm sorry, Sarah was brought in for the hearing. Okay. The Sarah was there. It it wasn't in secret. It just wasn't televised. And I guess she wanted the camera on her. I don't know, but that's the only in secret. He wanted to give his ruling on allowing Cashman to leave the case, and he wanted to do it quickly. Your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious, life saving time to fully and properly defend myself. I have okay, I heard another YouTuber say this, and probably somebody will say that I'm copying, but I did think the same thing when I read this. Her actually saying life saving time when she sat on her butt on a couch while somebody claimed they couldn't breathe. Well, that's rich. That's really, really rich, Sarah. Like, you lost me already. Okay. So on top of my already and still being violated constitutional rights and being forced to represent myself based on false information. What false information? Court you had 8 court appointed senators. And another one that you hired did left because you couldn't pay them. Okay. It's technically this is what 10th? Not the ninth attorney, but the 10th attorney. You know, I do not even know what is contained in said discovery after being withheld from seeing all to date. Here's the problem with Sarah Boone in discovery. Way back when, in the beginning, and this is being told like on many legal channels, in some of the commentary, and I've gone back to some of the earliest videos that were done on Sarah Boone. And apparently, one of the attorneys had told her she had mounds of discovery. It was boxes full, 4 or 5, like, and he probably said it casually. It does amount to 2 boxes currently as far as the paper goods, because during the 4 years that she has been waiting for her trial, we're going towards 5, right? some of this has been put on discs, and they will take like the files, like cell phone data and stuff like that, and they will put it on drives, on USB drives in discs, and they will put it in the box, and it saves a whole lot of room. Okay. But now that it's been condensed, Sarah is convinced in her mind that they lost 3 boxes of discovery that should be hers. And nobody's been able to come up with them because every single attorney says they have turned over everything that they were getting and nothing is missing. They have to sign it off. She forgets that there's a trail, but because they're not telling her, and they are telling her, well, it's on a disc, it's on this. Like, she knows, but she doesn't know. She knows, but she doesn't want to admit she knows. She's using any angle that she can. She wants to act like it was a surprise status hearing when she was notified and she was brought there, okay, to hear the results. And the ruling was done in front of her, with her. Okay. As a matter of fact, she's probably very lucky that there were no cameras, because it's being reported that she was so unruly about what he was doing that she had to be dragged out of the courtroom. Now, none of us saw that, but that's what they're reporting. I mean, and I kind of believe it. I bet you she went, the tone of this letter is totally belligerent. She is pissed. She's at her wit's end. Uh, I don't know why she didn't see this coming with all the complaints that she was doing. Did she think she could just complain her way out of a murder charge? Really? I think she should have stuck with a lawyer if she actually thinks she was going to complain herself out of a murder charge. Seriously. I don't even know what is contained in said discovery after being withheld from seeing all to date. And for the first time in said surprise status hearing, along with my supposed digital evidence being produced by Cashman, finally, after never being shown any of it during her representation, her response to me when I would ask to review was, "Your first attorney said he reviewed it with you." That was over 4 years ago. You're my new attorney now. And no, I did not. This is what I had to deal with. I have not seen it in its entirety and completely to date. And she refuses to believe what they tell her. Please note, I do not have access to a computer to view these materials. Wait a minute. Then how did she get the map of where everything is being viewed nationally across the country for her YouTubes? Where did she get all these figures? Where did she get all of those definitions that she actually copied from the internet when she was educating us all on how we should read her letter and what she meant? Um, I, no, Sarah, no. Mm-mm. They will provide you with a laptop. That's the law. You're just not going to have it 24/7 whenever you want. You're gonna have to compromise here. And you're gonna have to stop being such a stick, because if you don't make some movement towards cooperation, you're not gonna be able to adequately defend yourself. And as Judge Koenig said, that date's solid. We're not moving it because you get a new attorney or don't. He said that in the order. I do not have access to a computer to view these materials. I am doing my very best to figure this and everything else out as I go in my newly unwanted, forced position of pro se. Please do not penalize me even greater than being already. I'm trying. Please know also, I am in an open bay down living with 63 other inmates. I need to figure out how to view anything secretly to avoid further exploitation and mean ignorance. There is no privacy or individual access in jail. Cashman, I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing everything I've been asking for since day one. And after I included you on my letter to the judge ensuring return, unlike you who did not include me on your motion to withdraw. Surprise. Actually, there is says that she did. Actually, if you look at the motion to withdraw, she actually did. And I had to find out from someone else, an officer. You found out sooner than the paper got there, that's all. 3 days before the surprise status hearing. So you would even know what to bring. Why didn't you bring to any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. Oh yeah, you guys got your violins out? Get your violins out for Sarah. Oh my God, she went. What a whiner. I, I mean, I really felt for her being in jail for 4 years. But at this point, Sarah Boone needs to accept some accountability that she's been sitting in jail for 4 years because of her antics with her attorneys. How could they move forward? We spent so much time on motions to be excluded from the case or to be removed, then we have anything else. We haven't had any discovery things or witness issues. I mean, we've had some hearings in regards to getting stuff paid for, getting an investigator, getting a witness paid for. That's all gone forward. But you need an attorney to do it, Sarah. And the more that she delayed everything, the worse she made it. This is really, really getting to be too much. How much real time will I have to prepare and properly, especially the fact you have me doing everything while incarcerated? What happens when more time must be utilized to discover where my lost discovery is? I've been asking for repeatedly for depositions, to locate my witnesses, contact anyone via collect phone calls. That's a real hurdle. Wait to receive transcripts, any records, everything I need to finally build my defense. Or is your plan, Your Honor, to just leave me out to dry? And in a hurricane. I love it. Leave me out to dry in a hurricane. Hello, Mrs. Cassandra. Thank you for bringing Sarah her violins. Oh my God, this is too much. Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair, specifically that it has malformed by your ignorance and experience of my case, misinterpretation, straight lies from the attorneys appointed. There are brazen to stand at your pulpit in your courtroom and commit perjury to your face in the world. But yes, it's me. It is my belief, and from your order, that uh, that all actions speak louder than words. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included, cared, collaborated during their time of representation, you not being brainwashed, impartial from believing everyone over me and implementing your intricately misconstrued, unfair order formulated from, I would not be writing yet another letter, would I? In the meantime, dot, 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 while your clock ticks ceaselessly and loud as I wait for you to deliver anything, even more fingers are noticed. They really do point back. And I am defending myself against your inaccurate, libelous, I can write letters to order. Please, would you post my included document in your break room, wherever you think it may be seen and understood, unlike me in your courtroom? How about by the copy machine, where your eh, I guess it's assistants should have made me, the news crews, court TV, professional YouTubers, and photographers, the world, a copy of the notice of hearing, where all aforementioned improprieties occurred, and then some, including the drop off of my case materials. Said order being ordered and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise at even being there, unprepared and without notice. Oh, wait, my posting, everything supposedly is public record, and there is no notice at all. Another. It's in your favor moment. It's a group effort. It's a group effort. Saboteurs. Surprise! I shall return. Nothing is impossible. Believe. Hopeful, grateful, waiting. Thank you for posting. Oh, what a cheeky bee. Sarah Boone. Hmm. Remember, please, Judge Clenney, fair, neutral, impartial you must be. Always. Oh, now she's channeling Yoda. Oh my gosh. I can do all things through Christ who strengthens me. Philippians 4:13. And then here we go. And of course she mailed it. Honorable even on the message there. Oh my. Oh my. That's all I can say. Oh my. Let me just check my chat because like I need some refreshment. I need to refresh my soul here. Uh uh I have had a wish to give her the benefit of a doubt for some time now. I'm such a bad person. I know we've been trying, have we not? Sarah Boone refuses to hit the like button. I'm kind of glad she don't want to hit the like button there, Mousy. Oh, she's the only honest inmate in there, of course. She's the only one that didn't do it. I know. Yep, she shouldn't have got arrested then, right? Like, this is somebody else's problem, not hers. She did nothing, actually. Why can't Sarah, after 4 years, be declared mentally incompetent? Because she's not. She's actually competent. She's just not. She's just making it worse for herself. I mean, she's mental competency just means you need to be aware of the charges and what's going on around you. And she is. She just refuses to accept reality or compromise in any way. Sarah's got a my way or the highway kind of attitude that's gonna like highway her right into like a sentence. Like this judge, they have delayed it as long as they could. And she doesn't get to cry constitutional rights when she's the one violating. She she uses a lot of buzzwords. And after seeing that advertisement, she uses a lot of buzzwords. And I really do believe all these letters have been to speak to the public, to try to get someone, maybe some justice organization, to actually come forward in, support her in some way, offer her all, resources and opportunities and get her a lawyer. But like, no one's doing it. Okay. And for her to deny that she knows what's in her case, she knows. She's known from the start. She knows about those two videos. She knows about them from the investigation, from the interview. They found them while interviewing her. Wouldn't it matter if she had been if she had seen absolutely everything? Does she have the requisite education to understand it all? I think the more that she knows, the more dangerous she is to herself because she just goes on these tangents. You know, like the inability to understand it. 4 or 5 boxes could be compressed down to 2 boxes if everything is put on drives like it was. But apparently, the explanation she was given just meant that everybody was lying and everybody's against her. And if you are the one they're accusing, don't you kind of know the evidence they have against you already? Seriously? We saw her very active in her own interview. We saw the wheels turning. We saw how she changed answers to fit the new stuff they discovered as they went along. It reminded me very much of Barry Morphew, who every time a piece of evidence came out against him, had a new story to go along with it, already like ready to go. It was interesting to watch. Now, these are allegedly that Morphew did anything to his wife. Okay, that's alleged. I can't say he did or didn't. And the charges against him were dropped. But it just reminds me of that same interview. It really does. Okay. I always go back to other cases in similarities, and there's some things here with her changing of the story that really set me off. And I know why the charges are what they are, you know. I don't know, Mrs. Cassandra. I don't think she's gonna like the way I read her letter. I really don't. But it's kind of funny. Hey Beck, how you doing? And to anybody else I didn't get to say hi to, welcome. I didn't go too far back in the chat. But I am glad you're all here. I am glad you I am very glad that you're all here. The next one, I want to talk about this for a little bit because I think that we might be. I mean, the fact that the judge said he would not, now that she has to defend herself, he would not move the trial date, that she pretty much through her actions made it clear that she wasn't going to cooperate with anyone and that it's a waste of the state's resources to keep providing lawyers to her that she will not use appropriately for her defense and that she's unsatisfied with them. And at this point, they can't satisfy her and they don't have to. I mean, there is a limit to it. There he did state the statute, he did state the laws that were pertaining to everything in regarding to the ruling that he made, and I doubt he's going to get overturned. The only thing that kind of bothers me is the lack of time. Every time another attorney came on, he gave them a little bit of time. Even Cashman got a couple of weeks. I don't see. I do know that he wants to finish it by the end of the 2024, but I do think he should give at least another 30 days to Sarah, especially if on July 8th, which was 1 week, which is not that long, considering it has to go to the prison, the discovery I'm talking about, the 2 boxes of discovery that Cashman brought, they have to check everything to make sure it's not in violation of everything. The prison can't just turn over a box because somebody says it's good. Okay. Even though it's coming from, you know, the, the judicial system. Okay. I'm sure they didn't go over everything that was in that box before they turned them over. Okay. Um, I'm going to bring up my presentation because like they did sign them off. Like, that it did all get signed off because here on the record on her account is the order, okay, that he will not be moving the trial date. And also here's the box of discovery. The court will reach out to the jail to figure out how to get her this discovery and to release this all to her. They've got both boxes of discoveries like signed. They got them on that date, but on July 8th, she's saying that she doesn't have them yet. Now, that doesn't mean that they haven't notified her that they have them in custody and that she's got like tomorrow she can go see them. I have found Sarah not to be like she presents herself as 100% truthful, but I have found small things where she will outright lie about it to her convenience, like saying that nobody's ever brought her any of her evidence or that she is asking for requests of medical records that nobody has retrieved. And yet, the reason she doesn't like Patricia Cashman is because Cashman's like, don't waste my time. You've already seen the discovery with this attorney and this attorney. I've read all the notes. You have been brought the discovery. You know the case against you. Stop wasting my time. She asked for the medical records and she's like, Sarah, you had them. Your notes are all over them from the last attorney. The last attorney gave them to you, and this is what you did. It's so Cashman called her on her BS. I mean, that's in my mind. That's like a whole scenario. Like I could see the conversation, and I could just see Sarah's face. You saw that scrunched up face when Cashman was talking when she was in court. I could see the face and I could see well, let's just pretend the judge is here because you're not allowed to talk to me like that. You can't call me on my bullshit. Yes, she can, because a good attorney will and say, we need to buckle down and get this work done. You've only got a certain amount of time. We can't do a bail bond hearing. We got a trial in 6 weeks. Like, get a grip. It would take months with a bail bond to schedule the hearing and then go through, and the judge doesn't have to decide right away. So you're just going to delay things for months. You'll be in here longer than if we go to trial and get you free. She don't want to listen. Sarah does not want to listen. Sarah thinks she knows everything. and nobody else knows anything better. And if you do, you're an expert in something, you need to explain it to her A to Z. She's not going to believe anything you say. Anything. Okay, she believed a guard and an inmate over the process of notification on how to get a bail bond hearing rather than the actual law from her attorney, who did nothing wrong. Sarah was pissed because her brother wouldn't stand up for her, knowing that he was going to have to secure a location, like he was going to have to, money was going to have to be up. He was going to have to say that he would help. He didn't want to. He doesn't want the press. He didn't want his name associated with it. Like, who could blame him? Well, Sarah blames the attorney for that instead of who she should be blaming, and that's herself and the ruckus that she's causing. Okay. I mean, seriously. Seriously. Well, I mean, all of the certifications say they go to the jail. If there is a delay in how the jail actually gives her mail and whatnot, like I can understand that there's a delay. Well, as far as the surprise hearing, that was done quite quickly, yes. But they notified her, and they had to make arrangements with the jail, and they wouldn't make arrangements with the jail to bring her here if they hadn't notified her of a hearing. Okay, I don't know why she keeps claiming that she doesn't know about this stuff. How is it a surprise? Like, how is it in secret if you're right there? She was there. Her in secret, I seem to think, might be referring to cameras. I don't know. I don't know. She's got some visions of grandeur here that are really collapsing around her and quickly. But I would actually like, how is she gonna? All right, first of all, there's more. There's more. There's definitely more. And yeah, because it gets a little worse for Sarah. It does. July 22nd, yesterday, was the last day for pretrial motions to be filed, so they could be heard before September 29th, the pretrial status conference. Yesterday was the deadline, and I saw nothing. When I went in there, I saw nothing on on the court record. Now I can't print the actual documents unless they make them public. Okay, they have made a lot of her letters and some of the orders public, and there's notices, but there is no filing from Sarah. Nope, not since the order that Cashman could leave, in that the discovery would be given to Sarah. The only other thing that was added was that they would pay for depositions, for that, okay, as they should, but that's it. And then there was the letter on July 8th. Now that's not unusual. A filing can take a few days to be entered by the court into a public record. It does get stamped receipt and it's reviewed by the judge and etc. And it goes where it needs to go. But we're not like that important that it has to immediately show up on the website for all of us. Okay. So I understand it could be a couple of days. But I found it quite interesting that she's spending all her time writing a letter telling the judge how pissed she is when she has to depend on the judge's good graces to get some extra time. I think the last thing I would do is send a letter trying to reprimand a judge on his decision that he rightly has the right to do, and it's within the realm in his responsibility to do, because he doesn't work for you, Sarah. He works for justice, and justice is balanced between the defense and the victims or the prosecution. Okay, and this is not a victimless crime. We have a family and people who loved George Torres. Okay, and they need justice too. It's not all about you, Sarah. What the judge does is for both people. And I like how I'm just sitting here talking to Sarah like she could hear. Well, maybe she will. Maybe somebody will tell Sarah this, that it's not just all about you. Your life, as far as imprisonment, is in jeopardy. Like, your freedom is at risk. Yes, it is. And you could get convicted. And you're at great risk of that. But you're doing nothing to help that situation. You're only making it worse. And the reason that you've been sitting your butt in Orange County prison for 4 years almost squarely lays on your shoulders. The majority of the things that went wrong in the delays are your fault. Period. Then she really needs to get with the program. She got a pre-trial status conference on September 29th, the last one before the trial start date, this October 7th. And I'm selling tickets. Yes, get your popcorn, get that really big bucket of drink. Because like we can't play any shots games with Sarah Boone. We'll all end up like with alcohol poisoning for sure. Mm-hmm. It is. Hey, couch, how are you? The Boone heads. The Boone heads. I love it. I love it. I love it. Okay. All right. Yeah, I'll have one more. First, I'm going to go through the chat, see if you've got any more to add about Sarah. To be fair, it was a great letter. I'd go see whatever band she's trying to promote. What band was that again? I know it's like a band flyer. It is. It is. No, it's the Sarah. Please have pity on me and come represent me for free, just so you can get your name out there, because I'm going to be a star. Yes, it was that band. I'm going to be a star, Sarah. Yeah, or I already am a star. The look at me, look at me. I just don't. The oppressed opportunity. Yes. That's a good one. That's a good name for that band. Yes. That is a good name for it. Of course, Mrs. Cassandra. Of course, there's more. Yeah, the deadlines. Like, yesterday was the deadline on motions. Like, I'm watching that court record like a hawk. Yeah. I'll be looking at it tomorrow, too. You'll be seeing something on the community tab if she files a thing. Sarah gonna be like 84 years and you're still not listening to me. 84. Exactly. I've been in here for 30 years, which could be the actual sentence. Okay. And here we are. And I'm still here waiting for my trial. Yeah. I don't know how long they can keep you in waiting for a trial before they have to. I think that's one of the issues that the judge has to deal with, is making sure that they still stick within all kinds of state regulations in regards to timeframes and things like that. Remember, the state is not asking for anything to be delayed. It has been because of the changing of attorneys that most of the delays have happened. And also with the not being able to get things paid for, not being able to move forward with an expert witness, with an investigator who left, and then they had to hire another one. And that's another thing. She hires the investigator to do a job. Well, she's pissed off he won't come to the jail and personally tell her everything he's doing, so that she could tell him where to go and what to do, and you know, how we should question people, what he should find out. Like, yeah, she really annoyed with that. The attorneys are trying to explain to her they only have to issue reports. They're not required to come and talk to you. And she's acting like she's footing the bill. This is the state's bill. I mean, the arrogance there and the entitlement really is starting to annoy me. And when she signed off that letter that she was hopeful and grateful, she is not grateful. I challenge everyone who watches me, find anywhere in any of those letters where she is actually grateful for anything anyone did, without a snide remark before or after in regards to the same thing. Because she's like the backhanded compliment at all times, you know, with her quotes, in her, words in italics, in her bolding and underlining and phrasing that she uses. I mean, this Sarah Boone thinks she's all that in a bag of chips, and I'm sorry to say she's more like a smelly, soggy tuna sandwich that's 3 days past and the pickle is limp. This is not good. Sarah, you need to really start cooperating. You need to buckle down and worry about your case. Okay. And stop writing a letter to the judge. And you have an advocate in the prison. You ask a guard to speak to the person who's in charge. You say, this is my issue. You have a person assigned to you, like we do in all American prisons everywhere, that is to help you navigate the system. And if you'll piss that person off and they don't want to deal with you, which I highly suspect you already have. I mean, you had 4 years to do it. I'm sure you accomplished it. Hey, you're not using the system the way the system's designed to be used. The system is set up where you don't get to make the rules or say it's not right. You got to follow them and you got to get along if you want anything. You're in prison, not a hotel. You're not an esteemed guest of some resort. You're in prison being charged with a serious crime. Your living partner lost his life for for many different reasons, but the main one because you didn't bother to let him out of a suitcase. You're not taking any accountability at all. You need to start compromising. I mean, I can't even imagine her getting the sympathies. But we've seen crazier things happen. Yeah, we have. It brings me to my next one. Are you ready? Are you ready to see the face you really don't want to see? Let me just check the chat, before I'm trying not to annoy you, but these three women, like I was glad with the Courtney Clenney stuff, okay? Because I really thought that the charges that they put on the parents and her for that laptop because they made a mistake, because they literally got caught with their pants down, not doing a proper investigation. They took all the other devices, but they left a full laptop in the apartment. It wasn't hidden. They took all other devices, but they left a laptop. They got caught not doing very efficient investigating or documenting of evidence. They turned over the apartment and now they want to call foul, like, to a shared laptop. Yeah. I'm kind of glad that the law, like the Judge Cruz, actually looked at the whole picture of it in what they actually had access to when they pulled those cloud emails in, text messages, in what kind of conversations they were exposed to, which were in direct violation, which they failed to mention, by the way, to the judge, that they had to redact a bunch of stuff, that, this, that, or the other thing. They failed to come clean about it all and say it might be an issue, but that there's a more serious issue here, because it's not really a more serious issue. There's nothing on that laptop. They even said so afterwards. They're just pissed off that she accessed it. But it's a shared laptop. Where's the crime? Show us the crime. If you have the password to get into something, where's the crime? Hello? Like, where is the crime? Oh God, Sarah, when she sent that last letter, I get you. I get you there, mouse. I get it. Yep. All right, you ready for this one? Here she comes. Yeah, I hear you. Liam says, ugh. And you know what? He's right. Here we go. There we go. Karen Reed. Okay. Stuff's going on here that we need to talk about just to bring it up to date. Now, we all know we're waiting on a retrial. Um, we know that the mistrial was declared on July 2nd by Judge Beverly Cannon. Okay. This is actually from the hearing that was yesterday. She don't look happy for somebody that did not get put in jail yet. But anyway, there's a lot going on. We know that there was a motion. Also, I did want to mention this. She showed up, okay, to court with security. Now, normally, the whole doing the trial, 2 months of trial, she walked the streets with her supporters all over the place with her attorneys. Those are not attorneys. Those are security guards. All right. Now, this hearing, there was a whole bunch of like the free Karen Reed people all in pink, with that other YouTuber, whatever, yelling and congratulating herself. But there was also quite a large number, like there was another bunch of people there to support the O'Keefe family. And there was a picture circulated of John O'Keefe's mother. And for privacy reasons, I decided not to include that all here. I don't have any problem showing the defense because that is a three-ring circus and they love the publicity. I mean, what are they going to complain about, right? This is what they wanted. But I think the privacy of the family has been violated so much, and the witnesses have been through so much. I don't want to put those kind of pictures up and everything. Although I will say it was nice to see the support that they got, and they were smiling and they had thumbs up, and they recognized the people that were there supporting them, and gave them the thumbs up and waves and stuff like that, and which was good to see, because they had been rushing into the courthouse for months. Um, Even with the 200-foot boundary that has been set, um, that's going to come up because apparently there's a big issue with one of the jury affidavits that came forward. So here we go. We know that the defense, Alan Jackson and Yannetti, have filed affidavits in a motion to dismiss several charges that they heard from one juror direct. Alan Jackson gave an affidavit that said that he heard from one juror himself. And then Yannetti filed an affidavit that states, per him, through two other intermediaries, the statements of two jurors that conclude that Reed, that said that the panel agreed Reed was not guilty of two of the three charges, for the murder charge, and then for the manslaughter charge, leaving the scene of an accident when she knew that she had caused him harm. That those two charges need to be dismissed because they were only unsure of the one. Okay. Now here's the problem: the jury did not convey that to the judge. That's not how they put it forward. And well, I've been doing a lot of research into it. And well, this kind of reminds me a lot about the filing that Harpootlian and Griffin did in the Murdaugh case, saying that jurors said this, but there was no affidavit from the juror. It came through the attorneys, and then the judge had to bring all of the jurors in, and the jurors didn't confirm it. Something like that could happen. These were text messages that they say. They don't show you the text messages. Everything's in quotes. And rightly so, the prosecution has filed an opposition to the motion to dismiss some of the charges, saying this is after the fact. Not only that, it's hearsay, and it also violates jury contact restrictions in deliberation. They're asking them how they deliberated, which is a very big no-no. They're asking about the deliberation process in his mistrial coming forward. Now, they could actually have polled the jury at the time or requested at the time that a mistrial was put forward for Judge Canone to actually hold an inquiry with the jury and let the defense and the prosecution speak with them. That is allowed. But the defense never offered that. They jumped on the mistrial thing and left. But after the fact, this came forward. Okay. But it's noted that the jurors did not tell the judge that they reached unanimous decisions in any area. They did not fill out those verdict forms that way. Okay. Now, I will say that in the motion to dismiss that was filed by the defense, they addressed that and said that the jury was confused in regards to the process, if they weren't adequately instructed on blah, 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 blah. However, we do remember that there's a jury foreman, right? And there is actually somebody in contact with the jury. And had they had a question on how to proceed, they're allowed to ask the judge. They're allowed to ask a question and have it brought forward to the judge for the attorneys. And it could have been addressed. But they didn't do that either. So if they had any doubts about how to proceed, why didn't they ask? These are all things that I am thinking, well, why didn't you, if it's such a big problem and you're so offended after the fact, why didn't you do anything about it at the time? You could have just asked. I do think that things might be twisted a little bit here. Okay, but now we have to wait and see what happens. Okay, because there was a hearing yesterday, and basically it was just all about scheduling. That motion to dismiss is not going to get addressed. Okay, not yet. And also last week, citing another juror that actually had to file a motion for protection with the judge, saying that credible and reasonable fear for their safety and the safety of their family. Those are the words of the juror. that they could hear the crowds outside and what they were saying, and coming in and out of the courtroom was so stressful that they're fully aware of the notoriety of this case, okay, and that there's been contact with jurors and jurors' families members, and this juror decided to do something about it and told the court straight out that they wanted their name to remain anonymous and wanted no contact because they were in fear. And that should never happen in jury service. Like, this is appalling to me. I don't know how you guys feel about it, but I am gobsmacked, like appalled that it's gone this far. Seriously. People that are like doing their duty with their time. This is not a pleasant thing. They were on that jury for more than 2 months. Come on. Like, anybody contacting them or trying to harass them, shame on you. Shame on you. Like, get a grip of yourselves, people. Like, this is not right. Well, anyway, Judge Beverly Connell had to order that the list of the jurors from the first trial be indefinitely impounded. It originally was going to be only like 10 days until everything calmed down. Now it's just like forever. But that order does not preclude any juror from identifying themselves, but nobody is allowed to go and do it. Okay. They can identify themselves and they can come forward and speak to the public about their jury service. It does not inhibit the jurors' rights, but it definitely inhibits others to do what they've been doing. Okay, so that list is supposed to say secret. I mean, there's a YouTuber out there saying he knows this juror, he figured out who that juror was, who this juror was, and he is putting them at risk. And this is what they were talking about: credible and reasonable fear for their safety and the safety of their family. That to me is insane. It's heartbreaking, as well as like, I feel like I'm in the twilight zone. Like, it's insanity. It should never happen. It should never happen. At the hearing, not much was done. We have had the motion to dismiss filed to remove 2 charges from the new mistrial going forward, to have the affidavit changed, to have the complaint changed. We have the opposition from the Commonwealth, who clearly thinks that this is just a grabbing at straws hearsay. It's another circus play in, that, well, they're opposing it, obviously. They just want to go forward with mistrial as it is in all 3 charges and present the case against. Because the jury did not at any time indicate to the judge that they had any kind of problem. And in contest, in actual support of that, here is the jury's final note, okay, to the judge. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond reasonable doubt. Not 1 charge, not 2 charges, not 3 charges, the charges. They did not specify where the issue was. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Ergo, all 3, 2, but definitely more than 1. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. That is a very well written statement by all of them, the 4-person given to the judge. Nowhere in that would the judge know that they had come to a unanimous vote on any of the charges. Nowhere on that is there a question on how to proceed with anything that they could unanimously agree upon. Now, I can understand it if they were confused, but didn't they have an obligation to let the judge know that? Judge has a choice. She can do like we did in the Murdaugh trial, and they can actually question the jury, bring them in, find out what the issue is, especially if there's going to be motions from the defense in third party hearsay, and I can't say that enough. Again, we got people claiming not identified to be juror A, juror B, just like this one, that one. Oh, third party. Two of them aren't even the statements of the jurors. They are messages conveyed by other people than what the jurors said in text message to them, which could be taken out of context depending on how much of it was submitted to an attorney. Okay, where the attorneys know they can't get affidavits from them directly and are actually putting the information like we believe it should be because this happened. All that can actually do is actually show the judge that there needs to be an inquiry. Okay, because you can't just go by what is in there. I agree with the Commonwealth in that area, that definitely is hearsay and not straightforward. Okay, if those jurors really think that justice is being subverted here and are making statements like that about it, they need to come forward with their names to the judge and give testimony, and they will be required to. They'll sit on the stand and they'll have to say. But we all know how these big promoted cases get. Everybody gets their head full of that 15 minutes of fame, and it's exciting, and people want to talk to you about stuff, and you get animated, and you do. And things get taken out of context. Because what actually, if we go back to what happened in the Murdaugh trial, in that inquiry, what actually Hartpulian and Griffin actually stated that the jurors said, they didn't actually attest to all of it on the stand, did they? It was kind of twisted and convoluted, and it didn't mean exactly what they thought it meant in every case. And the only one that really had a big to do about it was one who didn't even serve very long on the jury and was not part of the deliberations for the plea. Didn't get to deliberate at all. And I keep going back to that and going, well, they can make that motion, but what can they prove? What can they actually prove? There's still going to be a mistrial. All right. What we did do at that hearing was we did say that at August 9th at 2 o'clock in the courthouse of Beverly Cannon, they'll be hearing oral arguments on the defense's motion to dismiss some of the charges. Also, Karen Reed did not have Alan Jackson there. She did have Yannetti. Well, she has a new attorney just for this motion to dismiss some of the charges temporarily. Marty Weinberg is her attorney there. It was an older gentleman sitting next to her at the table and researched. He's got a very good reputation. But he signed on for this motion in particular to make the case in regards to why those charges should be dropped if the jury came to a verdict. But you can't, because they didn't vote on that verdict, nor did they put in a verdict slip that said so. So I don't know where we go from here, except for a retrial, because they didn't conclude. Had they asked the judge the question on what to proceed if they decided on some of them, it would be a whole different story. But how do you actually say that that was the verdict when it was never submitted as the verdict? You know, it's just a mess. I didn't think the Karen Reed case could get any messier, but this is a mess. Like, this is definitely messier. The limitations in law in where it can go, well, are pretty broad, but it's definitely within the hands of Judge Beverly Cannon right now. And it does seem that she is being very thoughtful about it, because if they did not understand, she has to look and see if there's anything in the jury instructions that they received that could have helped them understand what they should have done going forward, or how they should have contacted people. Like, she needs to look at everything that happened. And I understand, because remember, the judge is the counterpoint. She's the balance for justice between the Commonwealth and the defense, between victims getting justice and the defense getting a fair trial. You know, but she got a lot on her plate. All right. They did set the trial date for the retrial, January 27th of 2025. So not that long ago. We're not going to have to wait another year or two. hopefully. But Janetti did have some issues. He's got a trial around the same time, and she set January 14th for the last pre-trial status conference. And he was saying, well, he hopes that everything will go the way it goes and blah blah blah. And she said, I hope so too. But if you need me to contact that judge, I will. She don't want to move the date. She wants this done too. She doesn't think it's beneficial for all of this, especially with jurors being harassed and things, witnesses being intimidated. That it's good to move this much farther out, and I don't blame her. We still have to look at what's going to happen in with Turtle Boy. I believe on July 11th he had his hearing, and some of the stuff uh, he did receive actually that he would get certain communications, but they were limited to a certain day and time. He's claiming that he got all of one of the witnesses' communications, and he did not. If you read the filing, he is again making things bigger than they are, which seems to be a trend right now. The Tates are doing the same thing about the Florida case. The judge said there was enough to go through with one witness, one of the defendants. Uh, Everyone else was dismissed from the case. The family, another woman, all dismissed from the defamation case that Tate had filed in Florida. But one woman's, who remains anonymous, was some of the statements that they said that she said did look to be like they could be evidence enough to go forward through discovery to a trial and not dismiss the case. In other words, there's enough there that you could argue it. They did not say that she lied. They did not say she defamed. They said we could go forward with this in her. Her part is not being dismissed. But of course, the Tates are saying they won and that she's a liar, and the judge said so. And I'm like, okay, I read the document. I didn't see that, but okay. Okay, same thing here. Like, I'm reading the document, and I do see statements that are third party made by people, but I don't see them being identified. And I don't really want them to be identified in a public filing that people can see because, of course, the jurors' names have to stay confidential now for their own privacy, whether they want to get the notoriety by going to the defense attorneys or not. Okay. I'm just like, I don't know what's going to happen with this, to tell you the truth. I don't. I am thinking that it would be in the judge's best interest to actually have an inquiry with the jury to find out what's going on. But how to rectify that if it is true that they did come to a decision and they didn't actually put it on the verdict slip? I don't know. I don't know. We have to go through the step by step on the jury slip on what to do. The if this then that of the whole thing. And it's complicated. I'm going to leave it up to the judge. I'm not even going to weigh in there. I just think it would be good for her to get more information from the jury themselves. And that would have to be public. We're not going to see because we don't want to know who the jury is. So I don't know if it's going to be public in regards to being filmed or being on video. I don't know. But I do know it's in her hands. And she definitely wants to hear those oral arguments soon. And she wants it taken care of. So let's look. This is making me want to watch 12 Angry Men. Yes, yeah, shades of the same. Yes, they should have poked at the time instead of complaining later. Yes, they should have definitely asked the question, or just to ask the judge what to do. Yeah. Oh, poor persecuted me. I hear you, Liam. She got security now. Yeah. Intermediaries. Yeah, exactly. I was going to say, is how the jury deliberated relevant? Yes, it is. Because like you're not supposed to pressure; it's supposed to be evident. Yeah, it is. But it's a sacred process here in America. The jury process itself needs to keep its integrity in its process sealed. Um, so they have the safety in the confidence to actually just vote their conscience, say what they need to say, ask the questions they need to ask. It's 12 jurors, 6 men and 6 women were in that room, and they're the ones that know what happened. Okay. Having a small, like a percentage of them come out and say something and not have the others agree or disagree in public is concerning. And this is why I think there needs to be an inquiry by the judge, whether it be done privately with the jury herself or with the other attorneys, and depending on what avenue she takes for the inquiry and how to set it up. And I think it needs to happen because I don't think there's enough information in just what the Commonwealth is opposing and just what the motion to dismiss the charges by the defense is saying, because it is third party. It's just what the lawyers want to present, and I think she's going to want to hear from them if there's anything she can do. It may all be moot if there is actually a precedent for this being too late to start over, if you know what I mean. Like, well, that's all well and good, but they didn't actually fill out the verdict or ask a question. There's nothing I can do about it now. So we'll have a retrial and you can address everything there with a new jury. You know, to me, that seems fair. Okay. I mean, yes, it would be a great win for, wouldn't it be a great win for the defense if they got the other two charges dropped and the only one they go forward with is the one that they couldn't decide on? I think that it would be a benefit to Karen Reed to not have the murder charge over her head, which is one of the ones that they said they unanimously both agreed on. I just think the judge would have appreciated the additional information so that she could at least steer them to the path of the instructions that would guide them in what to do. I mean, the Commonwealth listed a lot of precedents in their actual filing that actually supported case law, and that it's too late at this point. And what those that jury deliberation process that they had, it's the outcome that matters and the lack of outcome that mattered, and not whether they would have done this or that, because they didn't do it. And you didn't ask for them to be polled or questioned. You just accepted the mistrial and left the courtroom. The defense did not put forward a motion, and they were offered the opportunity to speak with them at the time. They can object. We all heard the judge ask for objections. As shocking as that is, yeah. The jury system is being really tested by the existence of social media. It really is. Yes. I agree, Liam. I agree wholeheartedly. I think that the defense are fishing for clues in how to adjust their strategy in the next clue. It could. Hmm. Yeah. Craven says, I'd rather get my 15 minutes of fame for something better than being a juror in a murder trial, right? Or having a controversial opinion on the process, right? I kind of hear you. Um, Sequestering all jurors would be rather inconvenient, but it could be the future we're looking into. If you want it private, we've got to do our best to make it private because currently it's not. And so on that, if they like, I'm gonna wait for a couple more questions. Um, Look at that. Oh, holding it out within 6 minutes. Within 6 minutes, I knew that I would give time enough for all three. Do you have any questions on any of the three women's cases that we discussed today on Sarah Boone, Courtney Clenney, or Karen Reed? If you think of anything later, please don't forget to like, share, subscribe, or comment on the back of the video. Ask me. I will do my due diligence the best that I can. I'm not a lawyer, but I do reach out and speak to lawyers if I have a question. I do good research and I try to make it as specific as I can to the case to the president and actually to like where it is, which is very important because every court of every state and every prosecutor, they have all different charging requirements and laws and regulations, you know. Question. The answer to life, the universe, everything. Yes, it is 42. 42. 42. Eh. And yes, I'm going to be putting out another read this week. It'll be either Wednesday or Thursday. And this chapter will be read by one of our friends that some of you in the chat are very familiar with. We're going to be putting out a read by Ponchi. Yes, the famous and one only Christ Poncher. Read for Restaurant at the End of the Universe. And that will be coming out this week. I hope you're all enjoying it and catching up. It is one of my favorite things to do, is the reading online. And this one's been a lot of fun. We're getting towards the end. We have like 4 more chapters after this one, I think. And that's it. Oh yeah, Craven is going to be punchy. Yes, show him some love. Yeah, show him some love. Well, on that, I'm going to wrap up. I hope you all have a good night. If you didn't have tacos, well, I feel a little sorry for you because Taco Tuesday is like the best thing ever. But, you know, whatever you did and whatever you abide and enjoy with, I hope it was good. Good for you. And I hope you have a good evening. And I will be back on Friday in with Mrs. Cassandra's good graces. I'm hoping to make that another WTF because that's the information I got. Like that's what's piling up already, more so than any of the others, you know. And I definitely have some more to put forward for that. So hopefully we'll see you Friday, and then again we'll be back on Sunday with more of Bear and B and absolutely nothing. Yes. Yeah, right, Mousy. That one is fun. I enjoyed it so much. Mrs. Cassandra and Wrecker and Mippet made it like so much fun for me, and it was like coming back home. Like I felt refreshed and renewed, and I'm looking forward to doing more of my cheeky, snarky, what the if. Like it was good. Mm. Yeah. Well, this, Craven, it's okay to be a few chapters behind in the Restaurant at the Universe because it's a playlist and everybody can catch up. And there's a playlist for book 1 too if you haven't even discovered it yet. But I would like more people to read Douglas Adams. It's good fun. It is. It's creative, imaginative, otherworldly, snarky, humorous, challenging. It's a good read. And it's timeless. It's a classic to me. Mhm. All right. On that, I'm going to put on the outro and I'm going to get out of here. You all have a good night. Thank you to my moderators. You're always so wonderful and good to me. Thank you to my members for showing up and being part of everything. If you have a bingo card you want to submit, send it to me by DM, email, or in the server in the bingo room. Just put the date and you will be entered into the monthly contest. We will be doing June and July, one winner for each month. Oh, and we'll be doing that in the beginning of August. In July is wrapping up pretty quick. Today's July 23rd already. So every single show you can do bingo for, and you can enter as many times as you like. Is you got a show? Just put the show date on there. You got to have a bingo on it though. Okay. All right. Thank you all for being here. And again, good night.